Hi, this is attorney Nicole Christie from the Christie Law Firm. And so today I want to talk to you about a plea and disposition for commitment. That means when the kids are not home, they're in foster care, whether with a relative or they're with someone that is what they call a core home, is someone that's not a relative or even a friend of the family. If they're not home with you and DCF is asking for what they call commitment, I want to explain to you the plea and disposition date. And I do have another video around plea and disposition when the kids are home under what they call protective supervision, but this is a little bit different. So again, the whole process of getting to a plea and disposition date includes a conversation you have with your attorneys, namely with me if you are one of our clients, where we talk about what are your options. For any plea or any allegations, you have a right to a trial or you have a right to engage in agreement with the state. And there are various reasons why you might have to agree to a plea and disposition. It could be a way of getting us closer to our goal, or it could be the facts are such that if we did go to trial, we wouldn't be successful and we would have lost some time waiting for that trial to happen. And so for the plea and disposition date, the court has to look at the allegations, and those allegations are not just that top form where they say the children are permitted to live under conditions injurious to their well-being, but what they really want to look at is those facts that support that. So what a court has to find is at least one of those to be true by a fair preponderance of the evidence. And so it doesn't mean a high burden of proof. It's not that high. It's a fair preponderance of the evidence. So if DCF makes 10 different set of facts and maybe 5 of them are accurate and 5 of them are not quite accurate, doesn't include everything, the court still has enough to be able to make that decision to find the kids uncared for or neglected or whatever is the actual allegation. And so at the plea and disposition date, you will be canvassed if you decide not to go to trial as to your plea. So what most people do, as I explained in another video, is they'll enter a nolo. Nolo means, or nolo contendere is the full Latin term, that you don't contest nor you deny, or do you deny the actual allegations. The reason for doing so is just as I explained before. DCF isn't always accurate, but if they're accurate about at least one of those things, it's enough for a court to make a finding. So rather than going back and forth about what's accurate, what's not accurate, you won't admit and you don't deny, but you want to enter this nolo so that you can take advantage of the agreement. This nolo form, it's an actual form, and that we would give that to you for you to sign. And so in that form, what you're saying is, number one, you know you have a right to an attorney. You know you had a right to a trial. You know you had a right to cross-examine and put on your own witnesses. But you're giving up all of those rights so that you can take advantage of this particular agreement without having to admit or deny. So that's what the nolo form does. It's probably one of the easier ways to deal with, again, all the allegations, because not all of them are accurate. And when DCF does these neglect petitions, they don't always put the good stuff. They don't put the things that negate some of the things that they're bringing up. They don't always put it from your perspective. What they're doing is trying to make their best case, and so they put in these allegations, all of which may not be accurate, but some of which could be accurate. And as long as there's something in there that's accurate, then the court could make a finding. So once the court accepts that nolo form, they're going to ask you a series of questions similar to the nolo. And it will ask you, have you had anything to eat or drink that could impact your ability to understand? They want to know if you are under the influence. You'd be surprised, but I've seen where individuals come to court under the influence. And so a court can't take a plea if they're not sure that this person is understanding what's happening. They will ask if you had enough time to talk to your attorney. Were you satisfied with their advice? You know you could have gone to trial. Are you giving up that right to go to trial? You know you could have cross-examined the state's witnesses and put on your own witnesses. You could have testified. And that you're giving up all of those rights. And also that you're doing this free of your free will and voluntarily, because they want to make sure nobody forced you, bribed you, because this is your rights as a parent. And they're so important that they want to make sure you've been thoroughly advised and that you know what you're doing and that this is voluntary. Once that happens, then the court would move towards what they call commitment. Commitment means that DCF has guardianship. They don't have, you still have your parental rights, but DCF has guardianship. And the way that I describe guardianship for DCF is similar to leasing a car. Now, when you rent a car, you know it has to go back pretty soon. There's a quick time. That's kind of like the order of temporary custody. It's just temporary. But commitment means you get to hold on. Just like leasing a car, you get to hold on to this car for a period of time, and I'll get to that in a moment. But you get to drive this car as if it was yours, but understanding eventually it actually is owned by someone else unless you do something about that. And so for that period of time that DCF has guardianship, you still have the rights to see your child, know what's going on, and even make some critical decisions about the child. But DCF gets to do that every day, making sure they go to their medical appointments, visits with you, get to school, and things like that. And so when DCF has commitment, the court will set out some series of dates, and they're very important to listen for. And so those dates are, number one, the permanency plan due date. That is the date that the court has to review if the child is still in DCF's custody. What's the plan for the child? Years ago, parents would, lose custody to their kids. The kids go into foster care, and I mean decades ago. And sometimes kids got lost. They just, grew up in the system or aged out, and nobody really came back to find out where are they, what's going on with them. And so now there are laws, literal laws, federal and state, that say that's no longer happening. And so there has to be a plan for every child in foster care, and that is reviewed on a yearly basis. The first one is typically 9 months from the time the child came into care, and then after that it's reviewed on a yearly basis. And the whole idea is for the DCF to come back to the court and say, this is what we've tried, and this is the plan, and this is where we're going on every single child. So you'll hear about the permanency plan due date. And then they'll have another date called the permanency hearing date. That is a date to hear about the plan. And so those two dates, again, coincide, or they're actually dated from the time the child came into care for DCF, and then yearly from there. My best advice to you is to make sure that you are steps away, or the child is already home by the time that permanency plan is due and that hearing date comes up. Because if you are months away and they're saying there's not a lot of progress, and they have to set another permanency due date, and you are not even closer as you get to that next permanency due date, it's highly unlikely that DCF is going to say anytime soon, hey, let's send the kids back home. If they don't see progress between a year or so and year and 15 months, they're going to be looking to terminate. Our office, we have a completely different type of plan that is half the time of DCF. We work very hard to get kids home even sooner, because we know that the longer that the child stays in foster care, is the harder it is to get them back home. And DCF can make it even more difficult. They can continue to raise the bar. So our job is to really work hard with you, or really work towards making sure we can get the kids home through your compliance, through filing necessary motions, for pushing DCF, doing whatever we need to do, because again, it's important that that permanency date that comes up says reunification and not something else. So this is the plea and disposition, and this is what happens at plea and disposition date for commitment. If you should ever need our assistance, please don't hesitate to contact us. Until next time.